Today is the 9th of July 2014. Attempting to call Gordon Airy, Deputy Justice's clerk, on 01274 390 111 at Bradford Magistrates Court. I was put through to his office earlier on, but he wasn't in his office to pick up the phone, so I'm going to try and phone back and speak to him again.
Bradford Magistrates Court. If you know the extension you require, please press 0 now, followed by the extension number. Otherwise, please choose one of the following options.
Good afternoon, Bradford Magistrates.
Hello, it's James calling back just to see if I could get a hold catch Gordon Airy in his office again.
Oh, right. No, but Richard's in.
Oh, Richard. Okay.
Yeah, just 1 second.
Thank you.
Hello, it's Irwin.
Hello, Richard. It's James.
Yes, hello there.
Hello, how you doing? It's
Good afternoon.
yeah. I heard you were on holiday. I wasn't expecting to get you until Friday. I was told you wouldn't be back in Bradford till Friday.
Just had a half. Yeah, I've taken a half day today, so I was off this morning. I'm back now for the rest of the week.
Glad to hear it. It's basically just a catch up, really. Did you get the email I sent on the 4th of July?
I may have done it. Maybe it will be in my inbox of nearly 200 emails. I said I've been back about an hour, so I'm not through them all.
Right, okay.
You know what it's like.
Yeah, it's
when,
just...
When you get off, the emails don't stop.
I know, I get about 200-300 a day myself. It's terrible.
We need them. It's a useful thing, isn't it?
Yeah, better than mail, I think, because you can always print the email out and it stands just as good as an actual letter. Providing you put all the sent and received information, time, index, and date and stuff. But yeah, it works out really well. I just wanted to, basically, where I am now with the council tax issue that I have. Is that I've now deemed both Bradford Magistrates Courts and Bradford Council to be deemed in error in the matter.
Yes.
And I'm trying to get a hold of Gordon Airy to motion to a magistrate or justice of the peace under the Civil Procedure Rules 40.12 paragraph 1, which provides that a judge can make corrections to an order without, with motion without appeal, and I'm wanting to see, if there's any other additional civil procedure rules that can assist in providing remedy, because as it stands, Bradford Council, despite communication attempts to, request the information, despite the fact that they've now been deemed in error and been given notice as such, they're still going to continue, obviously, to make claims based on something that doesn't exist. So, although both parties are deemed to be in error, I still require remedy. So, I'm considering sending...
What's the error then?
Well, the error is that the liability order that's allegedly claimed to exist has been found not to exist. So...
you say that, don't you?
Well, I do say that, and I've proved it, because neither party have been able to provide the said document within way more than enough time. I mean, you was given 14 days official notice, but I mean, communications have stemmed right back as far as the 11th of May, as far as Bradford Magistrates Courts are concerned. Bradford Council tax was their communications begun on the 12th of May, the very next day. So either way, I'm still looking to seek remedy to the matter, because I mean, Bradford Magistrates Courts and Bradford Council can claim the existence of the liability order until they're blue in the face. But if we're adhering to lawful court procedure here, it doesn't exist, and that is now my official capacity, and I'm in my lawful right to do so. I want remedy, because I don't think it's fair how council tax can continue to threaten with enforcement notices and letters and possibly the the execution of bailiff action, which, by the way, would be executed on a premises that I'm not resident to. So, you know, these are considerations that should have been taken into consideration upon the claim being made. Now, if due consideration had been taken into consideration, this could have all been avoided. Now, it's alright either party continuing to make the same claim until they're blue in the face. The conceptual weight of the case file itself is going to have to answer to the fact that no order exists and due consideration has not been adhered to. I mean, I can go down a list of lawful court procedure that has not been adhered to. I mean, the fraudulence of the case is unprecedented, and scaringly enough, it's also consistent with just about every other council tax claim that's made to courts right across the country. The seriousness of the matter is escalating now to the point where it can no longer be ignored by informed members of the public, and I think someone sooner or later, and I know that people in the courts and council tax are nervous over this issue, because they know what's going on and they know laws are being broken here. Lawful court procedure is not being adhered to. Our common law courts have been stolen from us and replaced with administrative courts. The council tax. The council tax.
About the courts, but I can't talk about that. We have to talk about the specifics of this.
Yes, I know your position, and I know this is what is really awkward, and we're going to have to sooner or later come together, because the facts are the facts, and as it stands at the moment, council tax are producing a bill, making their own claim, sending their own summons, holding a bulk hearing court date, which is not an actual courtroom, and the people in the courtroom who are council tax employees are then authorising their own liability orders and then not being able to produce them. I mean, the entire thing, the civil procedure rules here have been completely blown out of the water, and all that's left now is that council tax are giving us no choice but to respond with the criminal procedure rules. Now, I'm basically going to motion to the judge that I want remedy, and whether we do that through the civil procedure rules or the criminal procedure rules, I don't care, as long as the matter gets resolved, because first of all, there's the issue around the liability order that doesn't exist, and the other issue is, if it did exist, it's incorrectly issued, because it would be executed on a premises that's not in my name, that I don't live at, that I'm not resident to. It's just shocking how it's got this far, and the reason it's got this far is because council tax have taken advantage of the public who do not know the law, and they've been incrementally brainwashed over the last, since 1992, since the Government Finance Act come out, which does not state that a man has to pay council tax, which I'm not disputing we should pay. I just think that, I don't think council tax should be, assuming unconscionable contracts. I mean, all these, there are thousands upon hundreds and thousands of statutes. We can't all live by them. We are a common law jurisdiction, and statutes are written through the reason of, common law is the reason in which these statutes are written. You know what I mean? And the courts are going to have no bloody choice but to start adhering to lawful court procedure, or magistrates are going to start getting arrested. It is a very serious matter, so I think
it's something in writing for us then.
Yeah, I mean, absolutely. I mean, my entire report documents the whole case. I mean, there's a guy out there called Neil Heffy that his case has come to light, similar to me, and he works for he has got hundreds, and I'm not exaggerating this, hundreds of liability orders in his name for properties he does not live at or does not own, and that's because council tax are doing a rubber stamping facsimile. They're just doing a rubber stamping operation. It's a rubber stamping exercise. It's completely breaking the law. When I went into court on the hearing day, I was not allowed in that court with my unalienable rights intact. I was not allowed to request any. I couldn't do anything. I went to another court hearing, the one for, and I stood there in the courtroom and spoke. And I don't even think that magistrate was a real magistrate. If he is a real magistrate, he's been bought and paid for. I mean, he's getting backhanders from this council tax deal. You know as well as I do that the courts are receiving. They're getting money. They're getting funding for this room that's been hired or rented or booked out, and they know what's going on, but they're being very clever not to get involved in it, and it's going to have to stop. So in the email I've sent you,
whilst you've been talking, I've had a look through my inbox and I haven't been forwarded anything from you, sir.
Well,
so, have you sent it to a generic inbox to the Bradford Magistrates?
No, I've sent it to the same one that's been sent out. And again, the email is already in the report. It's already been added to it, and it's been sent with the same. It's been sent to the same email by the exact same means. If it's not got to you, then I think there's deliberate action to subvert justice here. I think that's what's going on. I think people in those courts need to start booking their ideas up, or they're going to start having police coming in there. It's going to happen sooner or later. You know as well as I, well, you might not know as well as I do, but the economy's going, it's on its way out. America's going to be first to go. We all know this. We all know that our sovereign nations throughout the planet have been basically overtaken by corrupt banksters and private corporations. We know this. It's not a matter of debate anymore. We've got decades of history on it. It's just the facts. The problem is I mean, I've got cases down my arm that prove fraud and perjury. TV Licence was one of my most recent ones, where they've acquired a search warrant.
Just stop me there, because...
Yeah, I know, if it's digressing, it goes, I know, I'm going off a little bit of topic, but...
I'm sure you're busy.
No, and you are as well, but...
So, you want to put it in writing, as you have done before, and Gordon Airy will be delighted to respond, or somebody else on his behalf.
Well, I've already sent the email to yourself and before. I know for a fact it's been sent. I can prove it's been sent, and I believe it's a shame that the courts don't send automated response confirming emails have been received. Council tax do. That's their Achilles heel. Because if they don't respond back, the email's been confirmed to have been sent. It's as good as, a confirmation by council is as good as me sending them a letter and sending it special delivery. They've confirmed through automated response that the email's been received. So this email hasn't been received and all this stuff. It's just not washing anymore. Because people are recording the fact that when they've been railroaded and bunkered and ignored for a month, 2 months, 3 months at a time, and then they record all contact attempts, it's obvious what's going on. It's obvious they're being ignored deliberately. So there's no hiding it, because the conceptual weight of the case file ends up meaning that it has to get looked at, because it just gets, all that's going to happen is it's going to go back to court. Another hearing's going to get issued. I'm going to attend that hearing, and then I'm going to get thrown out of court again. And I'm going to make the case with complete lawful grounding. It's just going to go on and on and on and on. So sooner or later, the courts are going to be in a position where they will be breaking the law. If they don't adhere to due process, I mean, if I have to, I'll go all the way to the High Court with it. I know that the civil procedure rules cover that. I've not looked into that yet, but I mean, as far as I'm concerned, I just want to hit you with one rule at a time, because I know what's going on over there, and I know the position you lot are in. But you need to be careful, because you can't just keep brushing this under the rug before somebody starts getting held accountable. It's only a matter of time. So I know you said to issue this in writing, but I already have, Richard. Do you understand that? I already have issued it, and I know it's been sent, and I know it's on that system. If it's not, it's been deleted. And Frank,
it hasn't come through to me, not in the last couple of days, and I would expect to have got it.
Well, I sent it on the 4th, and it's now the 9th. I mean, I'll send it you again today, but I want to send
Put
it.
my name on it as well, for my
Well,
attention, and then...
Well, I did do. I mean, I put for the attention of Richard Irwin in the subject. Now, I'll send it again, but the email itself will not be, you know, I've already sent you 14 days notice, so I'll put at the top of the email that the email has already been served and issued, and I'm sending it again just for the convenience of yourself, really, so that you...
I'll look out for it.
Yeah, but I need a response to it, Richard, because I need remedy.
I think I responded to the last time. I think I responded to your letter, didn't I?
Yes, but, I mean, again, I mean, I understand the position you're in, Richard, I really, really do, but you do understand that, I mean, let's look at the last letter you sent me on the 19th of June, you know, it says, I can confirm that the court does not possess a copy of the liability order which was issued by this court. Well, I'm sorry, Richard, but that's just not good enough. And it's, I mean, you try telling that to a real barrister. Be honest, Richard, what's a real barrister? I mean, if I do I have to I know, but do I have to get a QC down here? I mean, come on. You can't claim that something's been created from the courts and then not be able to produce it. It defies the whole purpose of lawful court procedure in the first place. It'd be like me.
Any barrister or solicitor would suffice to legally practice in the courts. So, Mr. Fellows, you send me that email and I will attend to it.
Yeah. All right, Richard. I will do. Yeah, thanks for your time anyway. I'll be in touch again. Thanks.